Hello, I'm Christopher Perry, and a very warm welcome to you joining the first part of our autumn 2020 cost vlog from Number 5 Chambers. I'm delighted to welcome Adam Burrell from DAC Breachcoft, where he is a partner and head of costs. Alongside Adam, I'm joined by Charles Crowe and Richard McLoughlin, both members of the Costs and Litigation Funding team here at Number 5. If you would like to find out more about any of us, or indeed any of the other members of the team, please feel free to click on the links provided. In this section, we cover remote hearings, early neutral evaluation and mediation in cost cases, and the fairly recent Court of Appeal and eagerly awaited Supreme Court decision in Ho and Adelekun relating to cost set-off in QOCS cases. If that whets your appetite for more, or perhaps doesn't rock your boat, please don't forget to watch part 2, where we discuss solicitor client assessments, in particular the success fee challenges following Herbert and HH law. We also delve into the new cost budgeting changes and the new Precedent T concerning variation of cost budgets coming into force on the 1st of October. Do hope you enjoy. Welcome, everybody.
Hello.
Hi.
Hello.
Where do we start? We're having a training session remotely by Zoom. These sorts of things have become the norm, haven't they?
They have, and long may they continue. For what it's worth, I think that remote hearings technology is great, and it's made things a lot easier. Certainly in cost disputes, it makes sense to not have to appear in person because, of course, generally we don't have live evidence in cost disputes. And as the profession gets to grips with paperless working, most firms, large firms, have been paperless working now for probably a decade. I mean, there have been firms that have been caught out by the coronavirus, but I think generally speaking, firms are already geared up to a remote type of platform, and long may it continue, I say.
Do you find that the courts are geared up for remote hearings? I mean, if we perhaps separate a CCMC from a detailed assessment, I'm finding that for a CCMC, certainly they are working extremely well. Remotely, be that by the telephone or over a video link. But when it comes to a detailed assessment where the court is expecting to have the file there in some form, that being able to or not being able to hand up that piece of paper or that CFA or that document to the judges is a bit more problematic.
I think it just takes a bit more work and thought. I have an oral review of a provisional assessment coming up in 2 weeks. The court has asked for a paginated bundle of documents. It's often the case that when you're in person, the bundle of papers isn't actually paginated. But because we're going to do it on the telephone, I think it's necessary and very helpful that my solicitor has taken the time to do that. So just putting that extra bit of thought into how it's going to work practically really helps.
What do you think about cost of assessment, though? Because I've seen some ridiculous, well, I say ridiculous, it depends whether I'm at which side of the argument I'm on, but 30 or 40 hours that have been spent preparing bundles on some of the larger cases. And courts will agree, that's a ridiculous amount of time, but still allowing 20 hours, 25 hours for producing bundles in larger cases.
I'm sure it'll become something that is quicker to do and cheaper to do in time as we get better automated functions for paginating bundles. But I agree that's the only way around it, because if you need to quickly refer to documents, you can only really do it by way of page number. And I still think there's a disadvantage with detailed assessments, at least at the detail of detailed assessments, in that, trying to scroll through, unless you've literally tagged the entirety of what could be a huge bundle, it's just not as quick to scroll through on a screen as it is to flick through to find the document that you want, and then to be able to literally handed across the desk, as opposed to then require the judge to do the same thing.
Mm.
And so I think there is a huge difference between CCMCs and detailed assessments in relation to remote hearings. And I think, my personal view is that time will tell, but I wonder whether or not it's only the preliminary aspects of detailed assessment which are really susceptible to remote hearings. Alternatively, we're just going to spend much longer on the detail than we otherwise would do.
Well, of course, one of the things that often is the case with detailed assessments, and I'm sure you'll agree with this, is that often once the points of principle get out of the way, depending on which way they've gone, the parties go outside. And I would say 8 times out of 10, at the very least, settle the case.
Well, I think they should have a standard order that there be a preliminary hearing in any contested detailed assessment where remotely you deal with the preliminary issues, and then you essentially go away and it gets relisted for an in-person detailed assessment of the detail if it doesn't settle in the meantime. And I think that would be a really proportionate way of going about using the technology that's available.
Absolutely. Well, I mean, one of the problems we've got with coronavirus is the availability of the courts. There are huge backlogs, and we've seen new hearing centres being opened, old courts that we thought were closed forever reopening their doors and dusting away the benches. But there is still a huge backlog. Is that the way to do it? That we might not get a full hearing like we used to. We might not get a 2-day or a 3-day hearing, but we might get a half day to deal with some preliminary issues.
I think so.
Yeah, and I mean one of the other points, I mean, perhaps that turns on to nicely, is early neutral evaluation. Because that's something that's been in the rules for a long time within CPR 3.1, that the court can direct a non-binding early neutral evaluation by the judge to give the parties some steer on at least what one member of the judiciary has to think about both parties' cases. I'm wondering whether we might see some of those, because what's often forgotten there is that it's not just something that the courts can need the consent of both parties to do in the same way you might have with mediation. The court can order that of its own volition. Maybe we're going to start seeing a lot more of that.
Absolutely, I think that'd be really helpful. I mean, outside of my cost practice, I know that the courts have been trialling it in personal injury RTAs. I think the difficulty with that is that the clients in those cases have such firm beliefs as to responsibility that if it's not final, they're not going to accept it. But it's good to try, because you don't know.
Well,
Adam,
I think that,
sorry,
did you want to ask Adam? Go for it.
I was just saying, Adam, you sit on the cost ADR panel. How do you see utilisation of cost ADR? Do you see, has that been a damp squib? Do you think early neutral evaluation might be something somewhere in between the two camps that might get off the ground?
My personal experience of cost mediation is, it's been a damp squib. There's been a little uptake from either side. When I say either side, I mean, if you like, the established defendant camp and the established claimant camp. But I think that's in part because, generally speaking, the established defendant stakeholders are well represented, and certainly on the claimant side, they're well represented. So in actual fact, an experienced cost practitioner knows what the file is worth and what's going to happen. And I think that actually itself needles out a lot of the need for hearings. The one frustration I have from the experience of sort of knowing what your arguments are and coming across opponents who also are well represented and know the arguments, we sort of know quite quickly what we don't agree on, and we're not going to agree, and it doesn't necessarily make that much difference whether we get a mediated possibility of a deal, because we need a determination. And the point that Charles made about the bundles and the detailed assessment, and should we have more remote hearings on sort of big points, sometimes you need to get into the nitty-gritty, and I'm not actually sure it's right to say it's easier or better on paper than it is in electronic format. I do absolutely get quite grumpy still with courts, and particularly, I mean, I have to say the SCCO are very soft on indulging claimants in particular who just haven't got to grips with technology. I mean, I was did a summary assessment in the SCCO a couple of weeks ago, and there was a phrase bandying around such as, "Oh, we are all getting to grips with technology, so it takes longer." And you think, well, you know, the internet's been around for a fair while, and the telephone, and you know, it's can you bundle or tab a document electronically? Well, it's called PDF Pro. You know, it's been around now for about 10-15 years. You can do it. It's not as easy as a piece of paper in the sense that you've got to use an application, you know, on a computer to learn how to do it, and you do need to learn. I mean, I'm of the age now where I find you know, the young kids that are starting out of university, this is second nature to them. You know, you speak to them about PDF Pro and bundling documents and tabs and everything else. I think of a tab as an actual piece of paper with a little sticky bit on the end. They think of tabs in the sense of what you can do with a PDF document. And I just think that we need to, what coronavirus has done, remote hearings and everything else, I think has just made everybody realise that for the last 5 years or so, we've said things can't be done a certain way because they just can't be. Well, actually, do you know what? They can pretty much be done if you have to. And maybe that's just it should make the court more accessible. It should make it easier to get a determination of a hearing, because it should mean that everything's just a lot more simple and straightforward. One thing that I find curious, and I'll try not to go off on too many tangents, but I do find it quite curious that we have, why do we need, when we've got no live evidence, video hearings at all? What's wrong with a telephone hearing? And I can remember when cost management came in, there was this great big reluctance from the judiciary up and down the country, where the idea of a cost management conference on the telephone was almost as if you were swearing to even suggest it. And in fact, a telephone cost management hearing works perfectly well. If anything, it works easier than if you have to mess around on Zoom and everything else. You just you have relatively few documents. Mm-hmm. I think lack of familiarity with the format to begin with was probably the biggest concern. But now I just think it's much better. And the one great thing is, I do agree with the point that Charles made about suitability of remote hearings as far as cost management is concerned. And I think we don't now accept that you can't do a cost management hearing on the telephone or on Zoom if you have to, or Skype for Business or Microsoft Teams or whatever. It's just a lot more efficient and a lot better. But I've forgotten what we were talking about now.
There are some practical issues though. I mean, for instance, sometimes where you want a quick word with your opponent, it's an interesting one, isn't it, with BT Meet Me, that people often don't realise. Judges
you've
already
got rooms.
As you get on there.
Well, you've got rooms. You got on all these video. I mean, I must admit, I'm not really sure how to do it, but on all these video sharing things, I did a training session the other day, and you can go into like a private little room, and you go into a different like little session, and you talk about things in your teams. I come at it from the point of view of you've probably, I know it's counsel of perfection, but you've probably exhausted your negotiation if you go into a hearing anyway, or you're at a point where things are intransigent, and last minute deals, I'm sure they still do happen and they're still possible. But if you've got a telephone hearing at 10:30, you can phone your opponent up at 10, can't you, and have that quiet word?
I think I have to say, I mean, from a personal perspective, the lack of travelling has been very good, and I found, generally speaking, that they've worked. If you have done a full slog detailed assessment, you get to the end where you've got to add the bill up and arrive at an agreed figure. The days of finding a conference room and getting your calculator hours and then going through page by page, that's a little bit more difficult over the telephone or over Zoom. But it's that, to be blunt, that's probably
Don't we all love doing hearings in our pants though?
Well, you speak for yourself, Adam. I like to dress stylishly all the time.
Can I just come back on the early neutral evaluation point?
Yeah.
Because I think there's a fundamental difference, isn't there, between that and mediation. And I agree wholeheartedly, where parties are well represented, particularly in valuable and contentious litigation, probably there isn't going to be even any value in early neutral evaluation, let alone mediation. But the advantage of early neutral evaluation over mediation, as I've found it, is that in cases that don't fall into that category, sometimes parties just need their heads knocking together a little bit, and a decent indication from a judge, and in the context of cost that might be in relation to hourly rates or generalized in relation to time, often is the difference between parties being able to settle or not being able to settle subsequently, even if it doesn't settle at the neutral evaluation. So I think there's something to be said for early neutral evaluation that's over and above mediation. But in terms of the cost context, I think it's valuable in combination with that preliminary hearing that I was talking about. So deal with the preliminary points and then give, as the judge, some sort of indication, you know, in terms of the time, having looked at the file, I think in rough terms, you know, it's going to go this way or that way. I'm not binding any future judge, but now you can go away with your preliminary decisions in your hand and with a view of a judge who may then be excluded from doing the detail. But, you know, it may well assist an aid settlement if that happens.
I think particularly when we're looking now at 6, 8, 9, even 12 months for 2-day plus hearings to be listed, if you can get your main points boxed off and then an idea of where you might be on other matters, it's ultimately going to lead to things being concluded a lot quicker. Well, moving on from that, so coronavirus has been keeping us interested. We're waiting for the Supreme Court to give a decision on the Ho and Adelekun saga, which it's almost like the Star Wars saga, isn't it? What are the Supreme Court going to say? Do they need to say anything? Was the Court of Appeal unhelpful by suggesting it needed to be revisited by the Rules Committee when they'd given a fairly clear decision as to where the law stood?
I would say so. Yeah, absolutely. It's from a practical point of view of largely acting for paying parties, it is a really it's a really important decision, and it's a real difficulty when dealing with parties who have the protection of qualified one-way cost shifting as to whether or not you can offset costs against costs if you're in a qualified one-way cost shifting scenario. Let's put it this way: if the Supreme Court say, and it doesn't matter how it does it, whether it says that Howe versus MOB was wrong, Howe below was wrong because it just reluctantly followed Howe, in that you can offset costs against costs in a qualified one-way cost shifting situation, a QOCS situation. If it says that you can't do it, then the rules are going to have to change. It's as simple as that. Because if you can't do it, then it means, for example, in a situation where a case settles by Part 36 before trial, then you can't offset your costs against the damages that the claimant gets, because that's not considered, according to Cartwright, an order for damages against which you can offset. So what it effectively means is that there is no point in a defendant making a Part 36 offer in a QOCS situation unless it goes to trial. I think that's got profound implications for personal injury litigation as a whole. Before we even get into debating whether or not it's what Jackson ever intended. I mean, there's lots of things that Jackson said should happen, didn't happen. On qualified one-way cost shifting, for example, he wanted the protection to be means tested. That didn't get through, and it will just mean that from a defendant point of view, I think that QOCS would then be it's gone too far, and it's just a protection which is too if you like, impregnable, and it will just lead to injustice. So, I mean, the only good news about Herbert and Adelekun, as far as the defendant's concerned, is that we're going to be ages before we get anywhere near getting a decision. I think that, so as it stands, because we have the doctrine of precedent in this country, despite what I'm sometimes seem to be told by people in the claimant camp, that's the law. It's as simple as that. The law is you can offset costs against costs. You can offset costs against costs in a QOCS situation, because that's what Howe said. Hoe versus Adelekun says it's not pure in curiam, it's the law. So until the Supreme Court changes the law is what it is. So you can offset costs.
Is this really a case for the Supreme Court, or is this something that should have been provided for and should be clear in the rules? And the reason this whole debate exists is because there is arguments on both sides, and the Court of Appeal have acknowledged that in the Adelekun 2 decision, powerful arguments on both sides.
Well, QOCS isn't, in the QOCS provisions themselves, cost offset is not expressly provided for by about 3 centimetres, because of course the offset provision is the rule which immediately precedes where qualified one-way cost shifting starts. So, I mean, isn't it the case that it doesn't have to say it because it's obvious, that it applies? Why should it have to? Why should it have to be? I mean, if the qualified one-way cost shifting provisions are a self-contained code, if that is the case, which is the only way it seems.
That's the argument.
Yeah, that's the argument. If it is a self-contained code, well, one, why doesn't it say that it's a self-contained code? And why is it contained within the body of another rule from which the argument must be you can't refer to the whole? I mean, it's just a nonsense. But yeah, I mean, here we are again, aren't we? 2013, the Jackson civil justice reforms, once again, sloppy drafting maybe. But we all know it was rushed in, and we all know it was, where there's muck, there's money, and that's what lawyers do, is argue about the problems.
It certainly keeps us busy. I know, Charlie, you've argued the other side of that proposition.
Yeah, well, I mean, offsetting is allowed in where both parties have the benefit of costs orders in their favour, and those can be offset. But the rules in relation to where the defendant has succeeded in getting a costs order in their favour are that can only, according to 4414, can only be offset against damages and interest. And I think the interesting thing, the reason why I would answer your question, does the Supreme Court need to get involved? My answer would be yes, is because I think it's very interesting that the Court of Appeal in Hoe said, well, actually, we interpret the rules on their face quite clearly as not allowing the jurisdiction to additionally offset against costs beyond damages and interest. And we disagree with how, but we're bound by it. But we actually think it was wrongly decided on the face of the wording of the rule. And if they're right, and if the Supreme Court finds that their interpretation of the rules is correct and that Howe was wrongly decided, then yes, I agree. It will come down to a decision as to whether or not the rules need to change. But even there, I have to say I have a slightly different view, simply that some people take the view, I'm not saying I agree with it, but some people do take the view that the whole purpose of QOCS was to maintain essentially a cost neutral position for claimants, that the worst case analysis for them is at the end of the case, they will have nothing and no liability. And in fact, in Cartwright and Venduct, I had a quick look at it. It specifically says the QOCS regime, and this is the Court of Appeal, is designed to ensure that a claimant does not incur a net liability as a result of his or her personal injury claim, that at worst, he or she has broken even at the end of the action. Now, if that is the Court of Appeal's understanding of the purpose of QOCS, then that would support a finding that there shouldn't be a jurisdiction to go beyond an offset against damages and costs. So I think there is something to argue about, and the Court of Appeal can't decide what the rules say on their face. And if it's open season, the legislators need to decide what they actually want. And I agree with Adam wholeheartedly that there are very potent arguments as to why it should be allowed. But equally, if that wasn't the purpose when the QOCS regime was introduced, then it would potentially involve a change. The one thing I would say about Part 36 offers for defendants is surely there still is an advantage or a benefit in making a Part 36 offer, that if you do subsequently beat that at trial, and at the very least you can impose your costs order in terms of offsetting against the damage and interest. At the very least, you've got that benefit.
I think the suggestion is, though, is that from a defendant insurer's perspective, having succeeded on the magic number there, to then have to write a check is a bit galling. But it's that question mark, isn't it? Is that were the rules there, as you say, for a cost neutral position from the claimant's perspective to focus their mind, or in reality, particularly where we're looking at a CFA situation where it's very rare for, under the terms of a CFA, for the solicitor to enforce against the client. So the real punishment is the solicitor. But then maybe the next step is, should the solicitor be punished if they've given duff advice to the client on a magic number?
Yeah, but of course, I mean,
question surely.
They still, I mean, you can still go for the solicitor if they non-party cost order or wasted costs. So you can still get to them, as it were. And yeah, absolutely. I mean, the big game changer that heralded qualified one-way cost shifting is, of course, that at long last the claimant had skin in the game, so that the point is that you can wipe out their damages, so that what they're going after is absolutely at risk. And I do agree that this is not about, from a defendant's point of view, making the claimant have to pay. It's taking away their entitlement in costs. Offsetting is taking away their entitlement to costs. That does, of course, mean, in theory, there's a shortfall, and that they'll be liable to their own solicitors for that shortfall. But I can't help but think, well, just welcome to the real world. That's what everybody has to do. And it's just, I don't see that it's anything but just the natural imposition of almost a real market risk of litigation. And there should be no such thing as risk-free litigation. So it's not about being cruel. It's not about punishing. It's just if you've lost, it shouldn't just be your damages that are at risk. It's your liability to your own solicitor's costs, which is going to be at risk. It shouldn't just be given that you're going to get all your costs that you're entitled to in a case where you've lost. I think you should, and of course, we all know in practical purposes. Let's just think it through. Let's say that you've gone to trial. You've not won in the sense of a Part 36, so your damages that you've been awarded have been wiped out. You owe your solicitor, say, I don't know, £50,000, and the defendant's going to offset 20 of that, so there's a shortfall of £20,000. Well, it's up to the solicitor then whether they are going to enforce that shortfall. It might be that there's a difficult conversation that needs to take place between solicitor and client, but in the real world, there are lots of difficult conversations that take place between clients and solicitors, and it's just, I think, restoring that balance.
In terms of, you say balance, I think you're right. In many cases, welcome to the real world is entirely appropriate. But the danger is if you remove the protection of claimants entirely, the danger, I think, that concerns people is that those who would otherwise have perfectly decent, low-level damages claims will potentially be scared off from bringing them simply because they can't run the risk of having a huge shortfall in costs if they fail to beat a Part 36 offer. And so they'll just end up not bringing their claims at all. I think that's the concern.
Yeah, or they'll be pressured to accept the offer, or they'll be pressured to settle early, which comes back then, I think, to the original point, which is this is all about making Part 36 effective. And if you can't offset costs against costs, I would say that the use of a Part 36 offer by a defendant becomes less attractive. Because, of course, if you go to trial and the defendant wins on their Part 36, I mean, the answer is, well, you should have accepted the Part 36. So we've all turned up and we're here. You're incurring the expense of the defendants, your own solicitors, the expense of the court, because you haven't accepted what, with the benefit of hindsight, was a very sensible offer. And why shouldn't?
It's going to be interesting to see how that unwinds. I think if I put my fiver on it, I think the Supreme Court are going to rule in favour of claimants, and then I think there's going to be pressure on a rule change which will reflect or modify what we see. That's my gut feeling.
Well, I can't bet against defendants, so I'll take you up on that. So
all right, there's
recorded. Five whole English pounds says the defendant will win. Chris says the claimants will win. So
you heard it here.